Good afternoon. Welcome to Long Live Third Parties Podcast. Free Press Media Press, Inc., a third parties books publisher, sponsors this podcast. I'm Andrew Bichard. Today I read the case State Ex Rel. Aachen versus Blackwell, 2004, Ohio 535, Ohio Court of Appeals, 10th Appellate District, 2004. Friends, today we're going to talk about a leftist third party and what they have done for ballot access. What leftist third party am I talking about? Are you leftist? Do you like leftist third parties? Think about that. The leftist third party of which I speak and which this case involves is the Socialist Equality Party. Would you ever vote for them? I voted for the Socialist Workers' Party. Some people say the two are very different. I still would, whatever the case may be with that, I still would entertain the possibility of voting for the Socialist Equality Party. Maybe in some future election, they might be an option for me here in Texas, in some race or another. So specifically, what happened in this case? Let's read from the record. It says, quote, Bill Van Aachen and Jim Lawrence are respectively presidential and vice presidential candidates for the Socialist Equality Party. Because their party lacks legal standing for electoral purposes in Ohio, they seek a place on the ballot as joint independent candidates under RC 3513.25. David Lawrence is a registered voter in the state of Ohio who claims standing in this matter by virtue of an alleged infringement of his right to cast a ballot for the candidate of his choice. J. Kenneth Blackwell is the Secretary of the State of Ohio, charged by statute with the supervision and conduct of elections in the state. Realtors on August 14, 2004, filed with the Secretary of State a nominating petition containing 7,983 signatures. The Secretary of State then transmitted the part petitions to the respective local boards of elections in the counties where the signatures were collected for the local boards to examine and determine the validity or invalidity of the signatures on the petitions under RC 351.05 and eventually return them to the Secretary of State, who would, if sufficient valid signatures were found on the petitions, place the candidates on the Ohio ballot. End quote. Like I've seen in a case or two before, the issue of independents versus third parties. In some other cases, because the parties couldn't get on the ballot as their given party, they did strive for ballot access as independent candidates. This is what our friends at the Socialist Equality Party is doing here. They want to get on the ballot in any way they can. So I applaud them. I imagine some people would stop if they couldn't get on the ballot in the first way, but they didn't do that. So let's applaud that. Great job, friends. Great job. This goes on to say the signatures were deemed invalid by the election people because of various reasons, such as not using cursive writing and differences between names of voters versus what's on the voter rolls. It says here they ended up getting 3,811 ballot signatures, at least valid, deemed by the Secretary of State. They needed 500, it says, so unfortunately they didn't make the mark. Still, that's a lot of signatures to get. I imagine that would be hard. When I ran for office, it was in the hundreds you had to get. But here they require in the thousands. So that would be quite the deal. They didn't like this ruling, so they challenged it. Here are the grounds that they challenge. It says, quote, the two principal reasons for disqualification that the relators challenge are, 1. The address given on the petition did not correspond exactly or at all to the address carried on the local voter rolls. And 2, the signature is not written in full cursive handwriting. End quote. This is a new issue. The issue of cursiveness. I have not seen it in another trial before. Maybe as I continue to review these trials, I'll come across it. The law states the signatures have to be cursive. So what do you think about that? Do you think that's a reasonable requirement? Do you think it's reasonable but misapplied here? Or what do you think about that? They also mentioned something I wouldn't have thought about. They say some of the people who signed the petition were Asian and they have different orderings of the names versus Anglo-Americans. They didn't address that too much, if at all, in this case, so unfortunately, they didn't get any points for that. They debate the definition of signature. Unfortunately, the court here says it has to be cursive, as such is required by the law. So ultimately, it says the following, quote, writ denied, motion to dismiss rendered moot, end quote. Our friends at the Socialist Equality Party did not win, but they did try. They got a lot of signatures. They didn't get enough to satisfy the election board, but they didn't stop. They wanted to get on the ballot. I like that. I am considering voting for the Socialist Equality Party someday, so maybe you will too. Good job. Let's applaud the Socialist Equality Party. Long live third parties. Goodbye.